I very much appreciate being here, first of all. I would like to get a show of hands of how many of you do not work in right-of-way. In other words, it's not your primary responsibility. Awesome. I really, really, really appreciate you guys coming. Now, whether you're here because you really want to learn about right-of-way or whether you're a captive and have to be here, hopefully can impart some information that will be of use to you. But I always like talking with the folks that we in right-of-way have to deal with because we're really partners in the end result. And that end result for us primarily is getting to construction, getting through that magic date, the add date, and eventually getting to construction. I do have a quiz question for you all. How many of you think that it takes too long to get through the right-of-way process? And be honest, be honest. Okay. Well, one of the objectives of this training today is to show you why you're wrong and why it doesn't take that long. And I'm going to blame some other folks. I'll blame any environmental folks here. Yeah, I'll be gentle with you guys, but yeah, there are some areas where things get bogged down, and I think the key thing for right-of-way folks is just the idea that if a project gets delayed, let's say in the NEPA process or in preliminary design, there is this assumption that, well, we don't need to move the add date. We just simply need to squeeze right-of-way and make them do things faster. And I offer another class, which maybe we'll do one of these days, called 50 Ways to Lose Your Money. And a couple of things about that. Number one, there are more than 50 ways for you to lose your federal funds. But there are 50 really good ones that we talk about in that particular class, some of which I will talk with you about today. Because one of my goals, I'm old. I've been at it a long time, since 44, and I've been on both sides of the fence. I work with Florida DOT. I recently worked for about 15 months with WashDOT up in Olympia. So, I've been on that side of the fence and kind of fussed at the feds from that side. I've been on the Fed side of the fence for 25, 26 years or so, and sort of fuss at state, from that capacity. So now I can fuss at anybody now, just take my pick. But, we are in this together, but I think there are some basic assumptions that need to be out there, that need to be understood about right-of-way and what right-of-way is about. So that's really the genesis of this particular class we're doing today. Now, we'll be honest with you on this. The federal requirements for right-of-way are right-of-way 101 for non-specialists. Originally, I titled this Right-of-Way Made Easy for Engineers. Well, that didn't seem to be necessarily politically correct, so we changed that to make it Right-of-Way 101 for non-specialists. But and it's really oriented towards just helping the folks that don't do right-of-way every day to kind of understand why we do the things we do in right-of-way. We're not totally insane, maybe a little bit, but we really do. There are certain methods to our madness, and hopefully today we'll get through some of those. I've got some very basic training objectives here. Hopefully when we finish up today, one of the things you'll be able to do, and I'm sure you're going to be able to do this because I'm going to get into that pretty quick, in talking about the constitutional basis for paying just compensation to property owners. And we're going to talk a little bit about what just compensation is. You should be able to define the major elements of the Uniform Act. The Uniform Act, as we'll talk about, was the major legislation that was enacted back in 1970. It's been amended a few times since, but it was signed into law by President Nixon on January 2nd of 71. And it really drives the federal regulations and in turn then the state regulations that are based on our federal regulations. So we are going to talk about that. And the other thing is just looking at the major steps in the right-of-way process. You know, and you'll, as you'll see, it pretty much makes sense, I think, what those steps are, but we want to get into a little detail about them. And as Scott had mentioned too, as we go through this, any questions at all that you have on anything you see here or that I say, please feel free to ask them. The only thing I would, as Scott and I have talked about, I would ask you, if you have questions that are specific to a project or a specific situation, if you can kind of hold on to those till the end, and then whatever time we have, and I do expect us to have plenty of time for those questions that we can talk about later. So anyway, we know what our objectives are here, and let me see. Oh, that worked. Whoa, fast on the finger. And we're going to start at the starting point, which is the Fifth Amendment to the U.S. Constitution. That amendment is amazing. I try to keep a copy of the Constitution with me because there's so many good things in here, but lots of rights that the Fifth Amendment grants. You know, the right to not incriminate yourself, not have to testify against yourself at trial, a number of other things. But the very last phrase of the Fifth Amendment is, "Nor shall private property be taken for public use without just compensation." Now, I'm coming to your house tonight. I'm working a project. I do a little work on the side. If you hang around long enough, in other words, if you get old and you've been around a while, you may get pulled to do some other things. And I've done work for the Federal Rail Administration, Federal Transit Administration. Right now I'm doing some work for Homeland Security, where we're going to be buying some residential properties. Can't really tell you much about the project itself. All I know is we're going to be acquiring some properties. And we are going to be buying some actually here in Marion County, in Beaverton, and up in Clark County in Washington. And so let's say that you're one of them. And I come to your house tonight and tell you that, you know, I need to use your property, so, you know, we'll be out here on such and such a day and get to work out here. You know, I'm not going to tell you much about the project necessarily, but just, well, we need it. And you're going to be fine with that, right? Are you sure? I'm sure. Okay, because one of the things we're going to look at is any property interest. Now, what's a property interest? Well, you could own it in full fee. You could have all of the property rights that are available in a piece of property. You could have an easement on the property. You can lease property. There's the whole basket, or what we call the bundle of rights, and we look at them as sticks in the bundle. Each stick in the bundle is a particular right. For example, if you own a property in full fee, you have right to, you can lease it, you can subdivide it. There's any number of things you can do, you know, as long as you're doing it consistent with your, you know, local codes and laws, that sort of thing. So lots of property interests. So what if let's say that I don't need your whole property, but I'm going to be doing some work on the sidewalk, a public sidewalk in front of your property, and I just need to get on a little bit of your property behind that sidewalk to do some work with that sidewalk. You'll let me do that, right? You don't care if I come out and do that, correct?
Depends.
It depends. That's my favorite answer to any question. It depends. Right here, just compensation for the private use or for public use of private property. That applies to any property interest, whether it's a temporary construction easement, full fee interest, or whatever it may happen to be. The property owner has a constitutional right to receive just compensation, to be offered just compensation. Which means, for example, and I've had this in working with WashDOT, for example, we had a situation come up where one of the regions wanted to take some shortcuts with regard to some projects they had where they're doing some sidewalk improvements, doing some ADA work on the sidewalks. And they wanted to basically just go out, tell the property owner, we need to get on your property, we're not going to be here long because we've got to do work on the sidewalk in front of your property. And they wanted to just plow out there and do it. You can't do that. And why can't you do it? Why can't you just do that? Because that property owner has a constitutional right when it comes to any public use of that property. And the one thing I would say about that is I think if you think for a moment, forget about your job, okay? Forget about whether you're a right-of-way specialist, you're an engineer, you're a NEPA person, whatever. I want you to think about yourself as a property owner. How important is the Fifth Amendment to you and to your rights as a property owner? So this is going to kind of provide the foundation for a lot of the rest of what we're going to talk about here. But I cannot overemphasize the fact that every property owner who you are going to impact with a project and from whom you need some property interest, it may be a temporary easement, it may be a permit where you're only going to be out there for a few hours, they have a right to be offered just compensation for the public use of that private property interest. Any question, anybody disagree with that? Anybody have any concerns about that? Cool. Okay, so we're good. We're good that far at least. Let's see. Okay. Whoop. Okay, it was working. Why isn't it? Try that. No. Excuse me? Oh, up there? Let's try that. No. Battery may have died. Well, here, I'll just advance it this way. I thought I would. Well, that's kind of disappointing. Anybody have a suggestion? Is Diana around? Let's see. Maybe can you advance it from back there?
Does the mouse work?
Excuse me?
Does the mouse, does it work?
Oh, the mouse. Let's try the mouse. There we go. Okay, I'll just use the mouse. Sorry about that. The Uniform Act, the interesting thing about the Fifth Amendment, where it says, nor shall private property be taken for public purpose without just compensation. What's just compensation? Any non-right-of-way folks weigh in on this. What's just compensation?
Fair market value?
Okay, fair market value. Anything else? Let's say, for example, that you're going to be acquiring ODOT's going to be acquiring my property, and you're going to be offering me fair market value. But you're taking my whole property, and I live there. I got my family there. We got to move. What about relo? Okay, we're going to talk about that. Interestingly enough, relocation assistance, not technically part of just compensation. The Constitution, there are a number of different cases that have come before the Supreme Court. One of my favorites was the Bauman-Ross case in 1897, because it defines just compensation to say that just compensation, the property owner should not receive less than what his property is worth, because that would be unfair to him, nor should he receive more than what his property is worth, because that would be unfair to the public or to the taxpayer. I think it's a very important distinction that the Constitution or the Supreme Court cases based on the Constitution make about what constitutes just compensation. Well, in 1970, Congress took up looking at how on federally funded programs just compensation should be dealt with, how relocation issues should be dealt with. As well, I was going to say, as you recall, most of you won't recall. I'm old enough to recall, but during the late 50s and particularly through the 60s, the interstate construction was massive. I mean, just going great guns. Well, at that time, different states had different laws relating to what property owners would get paid, and whether some states didn't pay relocation. They just paid, an amount to acquire and told the people you got to get off. It varied from state to state. Some states had, Florida was the state I started out in, had a kind of a rudimentary relocation program. It didn't cover all the things that the federal law covers, but it did provide some assistance. But I can remember, I started in '73, I can remember right-of-way agents who had been around prior to the act that were out acquiring properties, and what they would do is, you know, they'd try to get an idea how much the property is worth. And so they know the property owner's going to want more, so they're going to come in at less than what they think it's worth and make that offer, and then they got some room to negotiate. That's the way it used to work. It can't work that way since, and hasn't been able to work that way since the Uniform Act was signed into law. That act, by the way, we'll talk about the elements of the act here in just a minute, what's in it. But it's been amended several times. Probably the most significant amendment, probably the biggest amendment, let's say, happened in 1987 with the Surface Transportation and Uniform Relocation Act Amendments Bill, because it added some things to the Uniform Act, one in particular dealing with businesses that we'll talk about that wasn't in the Uniform Act prior to that. But the whole thrust of this back in 1970 was Congress recognizing that when federal funds are being used in a project, it doesn't matter if they're using them in Florida or Oregon or Idaho or, you know, wherever, that there needs to be some consistency, some uniformity in the way that property owners and displaced persons are treated. In other words, you know, let's say if Georgia, for example, said, we'll be out there in the morning with a bulldozer, so you guys be off tonight. Or, you know, maybe in, you know, someplace else, a little bit different from that, but still kind of the same concept. Well, Congress decided, no, if there is a federal dollar in a project, then we're going to have a uniform set of regulations that apply. Now, as we're going to see in a minute, one of the things that the regulations did was formally or statutorily define just compensation. Because except for Supreme Court cases, you can't look through, wherever I put it, the Constitution, you can't look through here and find a definition for just compensation. It says and the Fifth Amendment says you have to pay it, or you have to offer just compensation, but it doesn't tell you exactly what it is. We will see in just a minute that one of the key things the Uniform Act did was clearly define just compensation. Excuse me.
I put it there to see if it works.
Oh, okay, cool. Okay, let's try it again. Oh, yeah, there we go. Now, the Uniform Act itself, the Congress set out in there several purposes for the act. One is, this first one, with regard to acquiring property, you know, treat owners fairly and consistently, which kind of goes to the title of it as the Uniform Act. Encourage acquisition by agreement. I love this one because minimize litigation. I like to say, any attorneys in here? Oh, good, I can say this then. I like to say that the Uniform Act doesn't really like attorneys because it really encourages us to try to stay out of litigation if at all possible. If we can reach an agreement on a property, and as you'll see when we talk some more about the Act, there's opportunities in there to settle for amounts that may be above what our original offer is. But the bottom line is the Act itself kind of encourages us, if possible, and it's not always possible, but if possible, if we can avoid litigation and settle the acquisition of that property, that's really what we want to try to accomplish. Now, for people who are going to be displaced, you know, so ODOT's hitting my property, you know, and I'm going to have to move. The Uniform Act has a set of regulations that provide various types of payments and assistance to displaced persons and assisting them to get relocated to replacement sites. So treating individuals fairly equitably, sort of similar language to what's in the acquisition, and not causing disproportionate injury. Now, that comes up in a couple of odd places in the program, not necessarily always in the Uniform Act, but basically that's just talking about not dealing with people in a manner that basically where you're not being fair or equitable, where you're treating one person, I'm treating this fellow here, I'm going to try to give him as little as I can. This guy, he's a nice guy. And so, I'm going to sweeten the pot a little bit from him because he's, I like him, he's nice. This guy, I don't know, he's been tough. So, life is life. You can't do that. You cannot do that. And the Act says so. Now, this last thing here, because one of the things, and it's just natural that a project manager is going to pick up on, when I say the Act also encourages agencies to act efficiently in a cost-effective manner, what comes to mind? Okay, we can streamline right away, we can cut some corners, because the Act wants us to act efficiently in a cost-effective manner. Well, if we reduce some of these payments to people that we're making, for example, again, I'm going to need a little bit of his property for a little while to work on a sidewalk, but I'm not going to pay him any money. I mean, it's not a big deal anyway, right? So I'm not going to pay him anything. Well, that's not what this means, because the Act itself, the primary emphasis of the Uniform Act is on uniformity, consistency in your treatment of persons who are affected by the project, ensuring that property owners are paid just compensation, or at least offered just compensation. I'll talk a little bit about that in a minute, but that property owners are offered just compensation for any property interest that you need, whether it's a short-term temporary easement, or maybe even in the case of a permit. That they're still offered the appropriate compensation for that. But with all of that said, the Act does recognize that, if we can find some reasonable efficiencies in the program, we want to do that. And I know in mine, and I think also the case here with Chris Woods and myself, that we try really hard to help our states look for some of those efficiencies. We've been doing some things up in Washington, for example, that are little quicker way of doing things and how they used to do them. And we're doing them, with FHWA approval, that we've come to some agreement on how we can accomplish some things a little more quickly, and so we're trying to utilize those. So, but again, I want you to leave here today, if you don't remember anything else at all, I want you to remember that the primary purpose of the Uniform Act is to protect the rights and interests of the impacted persons. It's not that it doesn't care about you, the agency, but one thing it doesn't particularly give a hoot about one way or the other is your project schedule. Now, I know for project managers, for engineers, the project schedule, the ad date is like the sacred place. It's kind of like for Game of Thrones, getting to Westeros and being the king there. We want to, that's where we want to be. And so we got to get to that sacred ad date. Well, that's fine, and right away, folks will try to help you accomplish that as long as you understand what they're required to do, which, among other things, is determining and offering just compensation for any property interest that you are going to need for whatever length of time, 2 hours or 20 years or in perpetuity, for that property. Okay, let's see, so that did work. Okay. So the Uniform Act itself is broken down into 3 sections, or they're called titles. Title I has a lot of general stuff in it, including some key definitions, and we'll run across these here in a little bit. For example, the Uniform Act defines a person. Now, the interesting thing about that is, let's say that we're hitting we've got a project that's going to hit some properties. One of those properties, let's say this gentleman here owns the property, but all he's got on it is a bunch of junk cars. He doesn't live there. He's not actually operating a business there. He just has some old cars that he's keeping because he may need parts off of them later, or he may actually want to try to restore some of them. So he's got that, this piece of property. Well, we need the property for our project. By definition, even though we're only displacing personal property, he's a displaced person, okay? So person basically covers anybody who resides on, operates a business, a farm, a nonprofit organization, or simply has personal property sitting on that piece of property. In all of those cases, they are by definition a displaced person. Now, in terms of residential displacees, residential owners and tenants, we're going to see later, they're going to have rights to be offered comparable replacement housing. And what comparability is defined in, as we'll see here in a bit, in the Uniform Act. Just to give you kind of a little short war story about that, when I started with Florida DOT in '73, they basically had two different laws that applied to their projects when it came to relocation. For projects that had no federal funds, they had a state law which that did provide for comparable replacement housing. However, what it didn't include, which the Uniform Act does include, is that housing also has to be decent, safe, and sanitary. Well, what that meant was, if Florida DOT back then, and this changed not long after I got there, but Florida DOT, if they were acquiring property from somebody who's in basically a non-decent, safe, and sanitary housing, in a junk house basically, they could put them back into that. But you can't in the Uniform Act. Uniform Act, one of the elements of the definition of a comparable replacement housing is it's got to be decent, safe, and sanitary. So if you take somebody out of substandard housing, when you go out and look for comparable replacement housing for them and are then computing any payment entitlements that they may have to acquire that replacement housing, you have to ensure that, among other things, it meets the requirements as being decent, safe, and sanitary, which is one of the kind of benefits that came out of the Act. And if you think about it, think back into the 60s when the interstate program was going, particularly in urban areas. Where were they putting the interstate in urban areas?
Cheapest places possible.
Excuse me?
Cheap places.
Cheap places, absolutely. In areas of low income, often minority residential areas. So they were basically going through slum areas because it was cheaper to acquire that property. Now, and so up until the Uniform Act, some states, if they took you out of a slum, they could put you back in a slum. The Uniform Act changed that. It, again, in the definition of comparable replacement housing, it has to be decent, safe, and sanitary. And then what a displacing agency is and the definition of appraisal, which I'm going to have you tell me what that is here in a little bit. Those are the types of things that Title I of the Uniform Act covers. Title II is a relocation section of the Act, and it provides for various types of relocation assistance, such as taking people around to show them possible replacement housing. I had a project in Tallahassee, Florida years ago where we found out that a couple of the people in the neighborhood that we were hitting used the Meals on Wheels program. So one of the things that we did as a part of our assistance program, and now this is one of the things, this is a good point to bring this up, your schedule. That magic add date, the schedule that you want to adhere to. Your relocation folks are not, by this law, They can't just go out and say, well, here's some replacement housing, go look for it, here's a 90-day notice or 90-day letter of assurance, we're going to expect you out in the 91st day, blah, blah, blah. You can't do those sorts of things. The goal here is to get people, in the case of residential persons, give them the time to locate and get into comparable replacement housing. It also requires time to provide various types of advisory assistance, which again, helping them find homes. In the case of businesses, what's one of the types of advisory assistance we may offer to a small business? Well, we may want to help them get in touch with the Small Business Administration to see about the possibility, maybe if they're going to need a loan to help them obtain replacement housing. Now you'll see there are some things we do for businesses, but there is one particular gap as compared to what we do for residential folks. And so, they're often in need of various types of assistance. Your schedule has to allow for that. We pulled money when I was in the Louisiana Division office years ago. One of the projects where I pulled federal highway funding from was a project where, in their haste, the state failed to provide necessary advisory assistance to some displaced residents. This was in Shreveport. It was a low-income housing area. Some of the folks in there had some special needs in their and the state was actually using a consultant to do it. Well, the way the consultant contract was set up, every penny that beyond the payment assistance, but every penny that the agent spent on taking people around to show them housing, using their own cars or what have you, was a penny out of their pocket. A bad contract, a bad way to contract for services, or at least for that kind of a project, because it led to FHWA pulling dollars out of that project. It was an interstate project. We pulled funding from it because they failed to allow adequate time to provide the necessary advisory assistance. So relocation assistance, there's lots of elements that come into that. Moving expenses, if we, in this gentleman's junk cars, we're going to pay to relocate them to another site. I mean, they're personal property only, we're going to pay to relocate that to a replacement site. And then for residential owners and tenants, you're going to see, and we'll compute a type of replacement housing payment for each one of those. Again, what does all of that mean right there? In one word. Time. Whoever said that, thumbs up. You hit right on the money. You have to have time to be able to do that. And when you run into problems in preliminary design that kicks your schedule out some, and you don't shift that add date, and you tell right away you got to tighten up. Now, where are they going to tighten up, and what's the risk of that tightening up? Well, one of the risks is you may be tightening up one of those 50 ways to lose your money. So you need to be very attentive to the time that right-of-way needs to get the job done. Okay, the third section of the Uniform Act is a section that deals with appraisal and acquisition, and then it talks a little bit about the condemnation process, and I'll talk more about that in a second. But we basically defer where the state is doing the acquisition for a federally funded project, then we defer to the state's condemnation process, and they do vary around the country. If you want to find some real interesting differences in condemnation, go to Louisiana. You'll definitely find them there because they use the old their law is based on the old Napoleonic Code. So anyway, those are the three. Oops, I hit the wrong button. Why did I do that? There we go. What the Uniform Act says about just compensation. Remember, I said that you won't find a definition of just compensation in the Uniform Act. It's finely defined in the Uniform Act itself as It says, in no event shall such amount be less than the agency's approved appraisal of fair market value. Whoever said earlier, and several people said fair market value, yeah, that's basically, that's the heart of just compensation. But underlying three different elements of this definition: fair market value, obviously, because that's what we're shooting for. We want to offer the property owner no less than the fair market value of the property. Now, we can't offer more, but you want to offer no less than that. Because if you do offer less than fair market value, that's one of the 50 ways to lose your money. So we're going to offer that. It's going to be based on an appraisal. Now, as we'll see, there is an exception under certain circumstances to having to have a formal appraisal. There's a waiver of appraisal process for certain low-value, non-complex appraisal type assignments. But in the case where you're having to do an appraisal, we're doing fair market value based on that appraisal, and the appraisal has to be approved. So I want to look at each one of these three elements in a minute. The Uniform Act itself is implemented in federal regulations in 49 CFR, CFR standing for Code of Federal Regulations, Part 24. And it's pretty, the purpose of the, yes?
I have a question on the approved appraisal. Who is the approver of that?
I'm glad you asked that question, and I am going to answer it because it's a very interesting story, actually. And I'm going to get there in just a minute. Yes?
You mentioned something about, I can't remember.
You want to go back on the slides?
Possibly.
Okay, I think I can do that, actually. Crap. Maybe I
I didn't
can't.
want to lose it, but I guess I already did.
Okay. Well, if you think about it, just,
Yes.
what was
Thank
that?
you, Molly. Waiver of appraisal.
Going to talk about that.
Oh.
We are going to talk about, we're going to get there, because we're going to look at these acquisition, appraisal, relocation in a little more detail. So we're definitely going to talk about those.
And eminent domain.
Okay, yeah, we'll do that too. In fact, we'll define that and condemnation. Well, I'll do that right now. Eminent domain is the right, basically the right of the sovereign, the right of the government to take private property for a public purpose. So eminent domain is the right. So what's condemnation? Condemnation is the process by which that right can be exercised. Now, it's a little different for us in the sense that before we condemn a property, we're going to make an effort to reach a settlement with a property owner based on this offer of just compensation, which, as we know, is an approved appraisal of fair market value. So we're going to start there. If we can't get there, though, under eminent domain, we are then going to use the condemnation process that will then allow us to get ownership of that property. So I've got my offer ready for this lady's property. We set up a time to come out and meet with her, and I make her an offer. Now, what we've done, we've had an appraiser go out and review her property. An important thing about that too, and this is another of the 50 ways if you want to lose your money real quick. The Uniform Act, in fact, years ago it was referred to as the Muskie letter. Edmund Muskie was a senator from Maine, and evidently he pushed real hard for one of the provisions in the Uniform Act of being where the appraiser must contact the property owner and make arrangements with them to afford them the opportunity to accompany the appraiser when the appraiser goes out and actually inspects the property for purposes of making that appraisal. So that is a requirement. If the appraiser fails to notify the property owner and give them that right to accompany them, if they just go out and do an inspection, maybe they're out there on a day when the property owner's not there, they look around, they've made their inspection, they come back and write their appraisal report, then they've violated the Uniform Act. What does that mean? Well, it means that they're probably going to lose some federal money. And WashDOT's lost federal money on that issue before. So it was, actually when I say WashDOT, it was a local agency, but we don't blame local agencies. We put the blame on the state only because that's how if a local agency fails to do something, or say they act in non-compliance with the law, and so we want our federal money back, we're coming to the state and telling the state, give us our money back. This happened on a project in Spokane where the city had a bridge replacement project. They had $5 million of federal highway funds in acquiring a major property for that project. They acquired it, spent the $5 million of federal funds, but before the project went to construction, they had new city commissioners come on board who were opposed to the project, and they basically killed the project. So we did not go back to Spokane and say, you owe us $5 million. We went to DOT and said, you owe us $5 million. Now, how DOT would get their money back from City of Spokane? Hey, that ain't my problem. You know, that's a problem for DOT, no doubt about it, but ain't my problem. I'm getting mine from the state itself. But, so anyway, how did I get off on that? Because we were talking about eminent domain, and yes, Eddie?
You have mentioned it a couple of times, so I just want to clarify.
Yes.
When you say you're pulling your money, are you pulling all of the funds back or just the portion for that?
You know, there's this great regulation. I think, if I remember correctly, and I'm old, so I don't always remember correctly, but I believe it's 23 CFR 1.36. That gives us, it's almost like carte blanche. In other words, it's almost like we can do what we want. We can take money just from the parcel. We can take money just from the project, or we can take all your money. We did that one time, not for right-of-way, but for civil rights issues. In fact, when I was in the Louisiana division, we basically came back to the state. They had basically eliminated their civil rights program, so we came back and said, well, we're not going to be any longer participating in any of your work. No more federal money as of today. Well, the good news there was that didn't last long. The state came around pretty quickly on that, you know, a big deal. But no, that regulation that I cite, or if it's not exactly 1.36, it's damn close to it, but I think it's 1.36. It does give us the authority to pull it from a parcel, even a particular item on a parcel, or the project, or all of your projects. So it's pretty broad authority, if you will. Okay, so, and we are gonna move here. Oh, what time is it too? In about 10 minutes, we'll take a break. We're moving towards about 50 minutes of time here, so we'll take a break here in just a little bit. But anyway, so this purpose of the Uniform Act, implementing regulations, promulgate rules to implement the Uniform Act, which it does. And we've seen this in the Act itself, fairly treating property owners and displaced persons, and implementing the regs in an efficient and cost-effective manner. Okay, come on, let's do this. There we go. Okay, the right-of-way process itself, that's pretty much laid out to some extent, with kind of an exception here, in the Uniform Act, is this one. Now, can anybody tell me if you think about a total right-of-way project, okay, from start to finish, what's missing here? I know Gene knows it.
Negotiation?
No, that's actually kind of in the acquisition area. What do we get? Okay, so we've acquired. We maybe had some condemnation. We relocated everybody. What next? Property management. The Uniform Act, oddly enough, doesn't say anything about property management. In other words, once we've relocated everybody, we've done all of our acquisition. We've got our condemnation going. We've done the relocation. Now we're sitting here holding some property that's going to be under construction once we get through that magic add date. Well, at that point, the Uniform Act sort of drifts away, if you will, and we get into a different set of regulations in 23 CFR. And I think I may be talking a little bit about that later this morning. But this is sort of the... Now, the other thing that the Uniform Act itself doesn't really talk hardly anything about is plans and title. And from our standpoint, for the most part, right-of-way plans, title work is pretty much, how that's done is pretty much state-specific. But it's important, as we'll see, that, for example, when you send the appraiser out to appraise the portion of property that you require for your project, they need to have the title work. They need to know what they're acquiring, or what they're appraising, what they're going to be valuing. In the case where there's we're doing a partial take, then they're going to be looking. Is Oregon a before and after state? Okay, so they're going to looking at the value of the area being taken before the taking and the value of the remainder after the taking. They're looking at if there are damages to the remainder. So all of that is going to be part of the appraisal process. With the appraisal function, the appraisers need to have adequate plans and title so they know what they're valuing. And similarly, when we get to the acquisition phase where we're coming out here and I'm making an offer to the property owner to acquire their property, I need to be able to show them what it is, particularly if it's a partial taking. I need to be able to lay out for them, first of all, how much of the property, where we're taking it from, look at things like drainage impacts to the remainder, other impacts that there may be, if the loss of some landscaping or whatever, any number of things that the acquisition agent is going to then have to be dealing with the property owner about. So, plans and title become very important. One of you mentioned or asked a question about the approval of the appraisal. Well, the law says, we saw the definition of just compensation law. It's an approved appraisal of fair market value. But guess what? When the regulations were written, they expanded on this concept of approved and created a whole section of appraisal review. Now, what does that mean? It means, excuse me?
More time.
Yeah, exactly. Yes, absolutely more time. It does mean more time, and it means more cost. Now, there are some local agencies here, right? Some folks are local agencies. So with you folks, not only, and let's say, do you guys have an in-house appraiser that you use, or do you fee out your appraisal work?
We fee out the appraisal.
Okay. What about your review work? Do you fee that out also?
I've only been with the county for about 4 months.
Oh, okay. Well, this fellow's shaking his head, and that's fairly common for smaller local agencies. You have to hire an appraiser, but then what do you have to do? You have to hire a reviewer. Why? Because the regulation, not the law. I want to make this very clear. The law doesn't require a review. The regulations require a review. So when you have an appraisal done, that product has to go to a review appraiser for basically a second look. Now, I found it interesting just recently, and I don't know if you guys saw this or not, Scott, but the Office of Secretary of Transportation, USDOT, basically issued or they put in the Federal Register on the docket an opportunity for the world, really, to comment on regulations affecting various transportation, whether it's highways, transit, rail, or any of the other programs that the U.S. Department of Transportation is involved with. And what they stated in that Federal Register notification that they were looking for is regulations that are not supported by law. In other words, places where the law doesn't require something but a regulation requires it, because under the current administration there, and I'm sure everybody's seen that, there is an interest in trying to do away with regulations that are not supported by law. I found it interesting that there were very, very, very few comments, actually only two, did you see those two? Okay. That related to doing away with appraisal review. Now, the justification that somebody might make for it, and I'm not, trust me, I can't push this because from a federal highway standpoint, we got to deal with the law and the regulations. So this is what we require. If you have an appraisal done, you got to have it reviewed. That's our requirement. But if the office of the secretary or whoever is going to be doing the work for them and looking at these particular laws and regulations, if they look at that, they are going to probably discover that, yeah, it doesn't say in the law that you have to have a review. But as long as a regulation remains, you got to have a review. I think one of the things that can be frustrating, I know for me as a reviewer, when periodically I go out and review a project and I'm looking at a set of plans, you know, or particularly this happens a lot when I'm looking at properties that were acquired quite a while back and now somebody's coming, DOT wants to lease a little bit of that property. Usually these plan sheets that look like plate of spaghetti. I mean, there's everything and their brother on top of it. I remember back to when I was in the Louisiana Division office I was there in the mid-'80s, and they plotted their right-of-way plans on aerials so that you actually saw, from an aerial view, you know, you saw the topography, you saw where there were trees, where the buildings were located, things like that, and they plotted then the right-of-way lines and such on it, so and property lines. So, you know, that I always found helpful. But again, we pretty much rely on, you know, the state's processes or the local agencies through the state. You know, but what you're looking for, you know, you want to see the property lines, the topography, you know, the right-of-way lines, the widths that are to be acquired, the centerline stationing, limit of slope, easements, things of that nature. And then with the title work, the states vary on this. Some do their own title work, some you know, obtain title reports. And again, that's all relative to how you guys operate. We don't really have any specific regulations that dictate, mandate, or even regulate what you do here, because we really start getting kind of knee deep into things in the next phase, which is going to be the appraisal work. But you just want to be sure that your right-of-way plans or your title work are sufficient for the appraiser to know exactly what it is she's going to be appraising. You have to have adequate detail there. Any questions about that? Okay, so you tell me, what's an appraisal? Now, if you look ahead in your sheet to try to find the answer, you ain't going to find it. I've got 4 questions in here, and now on my presentation, the next slide you're going to see is the answer sheet. At the end of the day, or when we finish up this morning, I've got the answer sheets here which will spread out, and be sure to get an answer sheet for each of the 4 questions, and then you'll have a complete package. So tell me, what's an appraisal?
Determination of fair market value.
Determination of fair market value, okay. What else?
It's a report.
It's a report, okay.
I live next door to an appraiser, and I've talked to him a lot over the last few years, and I'm not really sure what he does yet to makes his money.
Well, let me pick up on something. You know, Scott said a report. Is an oral report sufficient? No. Okay. You can go, let's say you want to, let's say I find an old watch in my, you know, maybe my granddad had, and I'm curious as to what its value is. So I take it to a jeweler and, you know, show it to him. He looks it over, and he gives me he tells me, he doesn't give me anything right, he just tells me, that's worth $50, you know. Fine. For that particular purpose, you know, an oral valuation, oral appraisal, that's fine. It's not fine for our work. For eminent domain work, that appraisal must be in writing. Anything else before we actually see the answer here that anybody wants to throw in? Yeah?
It's sort of as a relative value. You know what I mean? Like a watch vis-a-vis other watches that have a certain value. it's gotta be.
Good.
done. Yeah.
Awesome. Relative value, and we're gonna see that here in just a second. The terminology may be a little bit different, but you hit it, you're right on the button there. I like that. Okay, well, we will look at what you don't have, and that is the answer sheet, but you will have it. Okay, this is how an appraisal is defined in our regulations. And I broke it down into some separate pieces here. First of all, it's a written statement that is independently and impartially prepared. Now, what does that mean? The first pink slip that I ever wrote as a Fed, my first assignment with FHWA was in the Louisiana Division office. I reviewed a project up in Alexandria, which is sort of middle of the state. There were about 90 parcels on the project. This was kind of a rural residential area. It was a road coming into the town of Alexandria. And they were all partial takings, strip acquisitions. Well, the DOT had hired 3 different appraisal firms to do the appraisals on them. They split it up about 30 or so parcels per firm. So I was out reviewing this project. So I started going through a few of the appraisals from the first firm and looking through them, and overall they looked pretty good. I have a few things that I had, some minor questions about, but overall they looked pretty good. Well, so then I picked up a few reports from the second appraisal firm. So I'm reading through them, and it's kind of like deja vu. I've seen that somewhere before. Where have I seen that? Well, I got far enough along in there to realize that it was saying exactly the same thing as the first appraisal firm. So I thought, well, let me look at the third firm's work. So I pulled some samples from the third firm's work, looking through it, deja vu all over again. I mean, the same kind of stuff. Now, this is what I loved about that particular, aside from the fact that we pulled $1 million out of their project, what I really liked about it was the smoking gun. Not only had they copied each other on it, in other words, what was said in the first appraisal was said here, said in the third, the very same, this just blows my mind, the very same identical typographical errors in each one of the reports. I mean, how much better does it get to say, it's not independently and impartially prepared. So we're pulling our funds on that particular project. And we did it because the appraisals have to be independently and impartially prepared. Now, does that mean they can't use some of the same information? Information sources, like the multiple listing service, if they go there to look at comparable sales, and this is where we're getting into the gentleman back in the back, his point about the relative relationships that, if I'm appraising say a 3-bedroom, 2-bath, ranch style home, in my appraisal, I'm going to be looking for similar properties that have sold so that I have some idea. Now, I may have one that's a lot like this one, but it sold 2 years ago. I mean, in most every detail, it's like this one, but it sold 2 years ago. Well, I can deal with that. I can adjust for time. Let's say if this one is $150,000 and this one sold for $125,000, well, I'm going to look at how much did the market change over that. Let me change that in a minute. I don't yet know the value of the subject. That's what I'm trying to find out. What's the value of this subject? So, but I do know that this comparable sold for $125,000 2 years ago. So what effect has time, the 2-year period between then and now when I'm trying to get a comparable value for this property I'm appraising? Well, maybe it was over that time, maybe property values went up 10%. So I'm going to make an adjustment to that particular value to reflect that 10% increase. Now, there may be some other adjustments. Maybe the subject has a garage and this comparable didn't, so I'm going to basically adjust down on that comparable sale. But you see, the point here is we're trying to come up with a value for this property that we're going to be acquiring based on the relative values as adjusted of these other properties. So that's sort of the process, that the appraiser is going through here. So we know the appraisal is a written statement independently and partially prepared by a qualified appraiser. Now basically the states all have their own requirements and qualifications for appraisers. And there again, that's something we kind of defer. As long as the state has them, we basically defer to the state's requirements. And then most appraisers, except those who and this varies from state to state. In some states, and I'm not sure if that's the same here in Oregon, in some states, appraisers who work for the state do not have to be state licensed or certified.
We don't allow that.
Okay. In other states, they do, so that varies. And whatever the state's policy is on that, we basically adhere to that. Now's my favorite part of the definition of an appraisal, my absolute favorite, setting forth an opinion of defined value. Let me ask you, you go to your neighbor and say, I know what an appraisal is. It's an opinion of value. Probably the first thing he's going to say, it's a supportive opinion. But it's an opinion. It's an opinion of value by definition. Now, as we'll see later here, it's based on information that this appraiser has gathered. We just talked about adjusting some of these sales that we're using to try to match them to the subject. But it's the appraiser who's making those adjustments. It's the appraiser whose opinion is going into that. So the heart of the matter is you could have two different appraisers appraise the same property and come up with different values. So does that mean that one of them's wrong? No, it just means they have different opinions. Now, that's not to say we don't find problems in appraisals. I mean, if there are mathematical errors, for example, or if the conclusion of value does not follow logically from the premises on which that conclusion is based, we got a problem. But basically, Scott goes out, Scott does an appraisal, he's done his homework, he's gathered data, he's made his appropriate adjustments, he has a written report. Remember, it has to be written, a written report, a written statement. And he's done that, then he's given us his opinion of value, his appraisal. And again, the fact that, now, one of the reasons I'm emphasizing this point is because when that appraisal goes to the reviewer, a reviewer might have a different opinion of value. And ultimately, it is the reviewer who is going to either set just compensation or provide a definition of value or recommendation of just compensation to the manager, depending on how it works in any given state. In some states, review appraisers are authorized to set just compensation. In others, the review appraiser provides a recommendation to the right-of-way manager, and that person or somebody else who's designated within the agency is a person who sets the just compensation. But I want just to emphasize again that an appraisal is an opinion of value. So if the appraisal has done a pretty thorough job as far as the adjustments that they've made, the data that they have provided to accompany their valuation, to accompany their report, then the fact that somebody else disagrees, that's okay. We've got some at least to work with. Where that also comes into play is, so I have that appraisal, and I come out to this young lady, and so I make you an offer, and by the way, I'm going to give you a copy of the appraisal to look at, and you take a look at it. Let me say, this is bunkum. I'm going to go get my own appraisal made. Well, some states, I don't know if Oregon does or not, some states will reimburse a property owner for obtaining, if they want to obtain their own appraisal. So I'm just not sure if that's done here or not. As of a specific date. Now, why is that important?